conducted properly, absent your client bringing an injunction. Is that correct?
Yes, Your Honor.
And under the deed of trust, wasn't then Valley Oaks entitled to seek a deficiency judgment? I mean, I'm talking about irregardless of whether there even exists anymore a promissory note.
Okay. Well, first,
I guess that's the question. Why do we need a promissory note in evidence at a fair market hearing?
this relates to another one of the issues raised in this appeal, that the plaintiff is seeking to recover a deficiency balance. And in order to determine that deficiency balance, you have to look at the note and those sums that have accrued under the terms of that note. And
Those same sums included in the deed of trust and in the construction loan agreement? The sums that were advanced wasn't.
no, Your Honor, because during the course of the interaction of the parties, there were additional advances made subsequent to the execution of the construction loan agreement and the deed of trust.
There were amendments made.
Changes in terms. And I might add, the question that both of you have posed was never raised or suggested by, I mean, just as an aside, even though I'm responding to your question,
I understand that.
was never raised at the trial court level. And one of the contentions set forth in the earlier pleadings, we filed a motion for reconsideration and a memorandum of law, is that this, as a real estate transaction, there was statute of frauds issues and requirements, and to that extent, that document was necessary. But again, and most importantly, it was not a defense raised below.
Okay, and did Mr. Campbell? No.
Crawford?
Did he have to be qualified as a custodian of records?
That was the problem with the admission of Exhibit 14, that the record reflects, and I've excerpted this in the briefing, that he didn't even know what a custodian of records was, and that that subsequently led Judge McVeigh, when it was offered, to initiate the fact that there had not been foundation. Now, he is not.
Isn't that making the assumption that you need a custodian of records for this document?
Yes.
And why is this the type of document? If somebody has personal knowledge about its creation, someone who directed its creation, why would you need the custodian of records for a company?
And I agree, Your Honor, that the evidentiary requirement is not limited to a custodian of record, but Mr. Crawford would not qualify as a person who could otherwise provide foundation for Exhibit 14. And the reason for that is his testimony was limited to the fact that he directed the preparation, had the lawyer draft the document. The testimony was that the company is based in California. Mr. Crawford did not offer any testimony regarding who the person who signed it, whether the person who signed it had the authority to sign it. His testimony was he never requested the originals of those documents. So even if that issue had been raised below, and that's a problem with the decision that Judge McVeigh eventually reached in his.
Once Judge McVeigh eventually reaches that decision, there's no objection on that basis, is there?
Well, I'm sorry.
But was there some objection after Judge McVeigh allows Mr. Crawford to testify as someone who has knowledge, whether you're calling him a custodian or someone who has knowledge? what was your client's objection at that point?
That did not happen at the trial level at all, Your Honor. All that happened at the trial level was that the objection was sustained, plaintiff was afforded an opportunity to submit an affidavit. We know that did not take place. And then in his ruling, the judge didn't say he was a custodian. He alluded to the fact that he directed the preparation of the document. His minute entry utilizes the terminology signing, but that's not accurate because he had no involvement with that. So our point is, under either capacity, the plaintiff hasn't established that Mr. Crawford possessed the requisite credentials to lay the foundation.
I'm belabor, but it seemed to me the argument was he doesn't even know what a custodian of records is. He's not the custodian of records for the company. But once the court's made a decision, well, this is someone who has direct knowledge, who directed the preparation of this document. At that point, was there some different objection that your client made?
That was the judge's ruling. So at that point, there was no proceeding. I mean, we're here in the context of this appeal saying that he had neither capacity, but in the context of the trial court proceeding, there wasn't an opportunity to do so. So as I indicated, Your Honor, at the trial court level, Judge McVeigh threw the plaintiff a lifeline to cure this situation and identified a single avenue, that of the submission of an affidavit, which, Judge Catani, I believe is relevant to your question, that the judge prescribed a single course for the admission of Exhibit 14 to be salvaged, and the plaintiff did not undertake that course of action. The
plaintiff explained what they were doing in lieu of that affidavit, and the court accepts that. Why is that necessarily an abuse of discretion?
They didn't explain it. That did not take place, Your Honor. Through the
Didn't they just explain why Mr. Crawford was competent to provide the testimony that they were seeking?
That did not happen at the trial level, Your Honor. And what happened was, during the closing arguments 4 months later, the plaintiff brought Mr. Crawford and then an affidavit 4 months later, and Judge McVeigh did not permit Mr. Crawford to testify and did not accept into evidence the affidavit.
Did not accept into evidence? Did he strike the affidavit? Did he order it stricken from the record?
He didn't act on it at all.
You know, he did not consider it.
Right. And
Did he say, I'm not considering it?
my recollection of his testimony was that Ms. Felk stated words to the effect of, "We've brought this affidavit," and then he said, "Okay, but not okay that I'm approving it." But he never said, in response to your question, Judge Brown, he never said, "I'm striking it from the record," and his ruling doesn't. He accepts into evidence Exhibit 14 in his ruling, but he does not accept into the record the affidavit.
Given this, your concerns about the record, our concerns about the record, or the questions we're raising, isn't this the type of case that cries out for deference to the Superior Court to handle this type of situation? And if there's not a clear abuse of discretion, why would we want to jump into this into this seeming mess of what happened with Exhibit 14.
Okay.
Why is that a clear abuse of discretion?
Fair question, Your Honor. I understand the distinction. It's a clear abuse of discretion because despite the latitude and deference afforded to the trial court in a bench trial is required to apply the rules of evidence. And the second issue that pervades this case is the notion of the stipulation that was entered into between the parties whereby the court was not permitted, and the parties agreed that the court would not consider any additional evidence. And Judge McVeigh, in his ruling, simply said, Mr. Crawford was confused. I'm going to accept this document into evidence, but he in no way justifies or explains excusing the plaintiff from its unambiguous stipulation.
Didn't he say something to the effect of it was likely an oversight? Weren't those his words?
Okay. He never said, the oversight is the failure to submit the affidavit earlier. In order for there to be a basis, and we've referenced the harsh case that both parties have cited, in order for there to be a basis to excuse the stipulation, there needs to be something in conjunction and in the context of the entering into the stipulation itself that falls within the inadvertence, mistake of law.
Why isn't that part of the same issue? Isn't it just it's oversight if the parties enter into it, not remembering that they haven't, if they needed to clarify whatever record needed to be clarified with regard to Exhibit 14, and this is simply look, this was oversight. Why wouldn't the court have discretion to say, okay, I'll let you do that. I'll let the other side, if to the extent you want to do something different, you're free to withdraw from the stipulation, or if you think we need to go over the numbers to come up with the value of the deficiency, I'll let you do that. Why isn't that within the court's discretionary authority? Because
that's not what the court didn't conclude, that there was oversight. We've cited in the brief Judge McVeigh's comments where he expressed, it's on page 14 of the reply brief, he expressed to Ms. Felk when she was trying to explain the circumstances relating to Ms. McNair entering into the stipulation. He goes on to say, as far as the court's concerned, she did stipulate to have the court render a ruling based on what the court had heard so far. And I think she dropped the ball. I don't think there's any way of getting around that. And, to say inadvertence or oversight is a change of heart, a change of mind, would diffuse the effectiveness of stipulations in general.
And is a party ever prohibited from requesting leave to withdraw from a stipulation?
Yes, Your Honor, and there are precise standards for that, and the case law that we've cited on page 15 of the brief also highlights that valid stipulations are controlling and conclusive, and both the trial and appellate courts are bound to enforce them. So your question, Your Honor, is precisely the abuse of discretion, that Judge McVeigh did not have a legal justification to excuse the...
But you're saying an oversight is never a grounds for withdrawing from a stipulation? Let's say there's something, it's mistyped and there's a clear mistake. Just the parties have entered into a stipulation, they look at it here in the courtroom and they say, oh, this was a mistake, we intended to do this. Why can't a court say, well, I'll...
I agree 100% that that's permissible, Your Honor, and the harsh building case cited by both parties permits inadvertence, excusable neglect, fraud, mistake of fact or law as a basis to get relief from a stipulation. But that didn't happen in this case. That the judge specifically expressed that whatever subjective opinion or second thought you may have, the language of that stipulation was unambiguous. And, frankly, the purpose of that provision, and I mentioned this in the pleadings, is it wasn't the defendant that asked for that provision. It was the plaintiff concerned about the fact that Mr. Wright might subsequently want to attach to his memorandum his tax returns, which were relevant to the 1099 C issue. So it was the plaintiff that requested that provision be.
But there wasn't any, really a big surprise. This issue had come up before, and the plaintiff had said, we'll correct that, we'll provide an affidavit to take care of the foundation problem. So that's not really any kind of new evidence, is it?
That position was argued by the plaintiff below and rejected by Judge McVeigh. I think that's all my time. Thank you.
Your Honors, may it please the Court, Francie Felper, Valley Oaks Financial Corporation. I'd like to leave off on Judge Catani's question that it was not new evidence, that the fact that the trial court relied on Mr. Crawford's testimony at the fair market value hearing where he discussed that he originated the loan, he was responsible for all the loan documents, he was responsible for organizing the trustees sale, that it was standard business practice for Los Padres Bank to transfer all of the assets from Los Padres Bank to Valley Oaks Financial for any loan that was going into a trustees sale, and that he was responsible for making sure that all the documents were signed. He kept a file in his office, and that this is what the court relied on. We don't even have to go to the affidavit. We have to start from the record that shows that Mr. Crawford was the appropriate person to authenticate this allonge. And that Mr. Crawford didn't need to be the, quote, custodian of record. In fact, my client doesn't even have an official custodian of record, yet he was the appropriate person because he knew the facts of the loan. He knew the people in California that were signing the documents. In fact, the court limited previous counsel's time at the hearing. Therefore, she did not have time to say, let's look at other bases that we could admit this, but rather was trying to save time and get to other issues by saying, could I submit an affidavit from a custodian of record in order to authenticate this? Because it's true that this is a valid document. And at that hearing, and since, there's been absolutely no evidence that shows that this allonge is not an authentic document. There's been questions raised, but there's been absolutely no evidence presented versus the testimony of Mr. Crawford. And the trial court is in the best position to examine the authenticity of the testimony, the validity, the credibility. And like you said, the trial court based the record off of the testimony of Mr. Crawford.
But did Mr. Crawford testify as to who signed the document? Did he know who signed the document?
He did not testify, Your Honor, Judge Brown. He did not testify at the hearing that he knew the person. He did know the person. In fact, when previous counsel was trying to go through various documents, the court said the point of this hearing is it's the fair market value hearing. We don't need to go through all of these intricacies of the documents. Therefore, he could have testified. He was not given that opportunity to do so.
Okay, can you help me understand what the significance is of you or your colleague submitting the affidavit later, several months later? Did the court or not consider the affidavit that was submitted later?
The affidavit, contrary to appellant's counsel's remarks, the affidavit is part of the record. It is number 36 in the record. It was not admitted into evidence, but as I said earlier, the trial court reviewed the testimony from the fair market value hearing.
Stop for a second. It was not admitted into evidence when at the February hearing.
Well,
Obviously, yeah, right. At the prior hearing, it was not admitted. Was there a subsequent hearing at which it could have been admitted?
That's correct. The events of this occurred that.
No, there was no further evidentiary hearing, or there was.
Well, there was a hearing on June 28th in which the affidavit was filed prior to that hearing and discussed at that hearing. It was not a specific evidentiary hearing. It was on the post-trial memorandum, but it was discussed and it was part of the record. It was not admitted into evidence. There was no further evidentiary hearing, Your Honor.
Did the court give any indication whether Judge McVeigh, did he give any indication whether he was or was not going to rely on the affidavit?
Well, in his minute entry, it's clear that Judge McVeigh relied on the previous testimony from the fair market value hearing. That was enough. He didn't have to get to the affidavit, Your Honor, because he looked back at the testimony, relied on the fact that Mr. Crawford was confused. It's most people that aren't lawyers don't typically deal with the term custodian of record, and that appellant's counsel tried to make him think that he had to be in charge of every single record and every single loan for the entire bank that's in multiple states in order to be a custodian of record. Therefore, he appropriately said, I'm not in charge of all those records. He's in charge of all the records for the loans that he's in charge of. And he was in charge of all the records for this loan, and that's why he was the appropriate person to testify.
Did Judge McVeigh says, I may just be misremembering, but Judge McVeigh at some point says, I can't award any kind of deficiency without Mr. Crawford's testimony or without this exhibit, without the allonge or whatever we're calling Exhibit 14. Is he referring to, I can't award a deficiency without testimony from Mr. Crawford or without this exhibit? Was he relying on the exhibit?
I believe he was relying on the exhibit, but Mr. Crawford's testimony, as you said, could have also authenticated the fact. He testified that it was transferred and that he ordered the document to change it prepared, but the trial court did believe that it needed this document to award the deficiency to Valley Oaks, as it was the new holder of the note according to the launch. And as Judge Brown indicated earlier, the trial court has an enormous amount of discretion. The trial court heard all the evidence, they saw all the exhibits, he heard all the testimony at the various hearings, and he struggled with this issue. It was a difficult issue, but this is what we want trial courts to do. We want them to look at all of the record, all of the testimony, and make the right decision. And he realized when he reviewed the testimony from the fair market value hearing that he had made the wrong decision. And he laid it out. He laid out that he was saying that this was oversight, as Judge Downey referred to earlier, and that previous counsel had requested to submit this affidavit. And any statement where I indicate...
He made the wrong decision, or wasn't he just saying that counsel neglected to put something in the record that might be necessary? Are you suggesting that Judge McVeigh made a wrong ruling, or said that he was wrong earlier, or just that, was he correcting himself, or just simply allowing counsel to correct an oversight?
I believe it's the latter, that he was allowing counsel to correct an oversight, yet it was implicitly indicating that his earlier ruling based on the testimony could have been incorrect. And here there are...
Well, let me just make sure I understand that. His earlier ruling about the necessity of the exhibit was incorrect? Is that what you're saying?
That his earlier ruling, Judge Downey, that Mr. Crawford was not a custodian of records and therefore could not authenticate the launch was incorrect. That's what he was saying. He didn't need to be a custodian of record, that he had personal knowledge about the documents, he had personal knowledge about the loan, he had personal knowledge about the people who had signed these documents, and he received all the documents and kept a file. He didn't have the original documents because those were kept at the loan center, but he had a file in his office in which the loan documents were. And he made sure that everything was signed and in order. He
But
didn't
that-
implicit.
But that evidence was presented, or that discussion occurred before Judge McMay made his ruling. It seemed to me the focus was simply on whether he's a custodian or not, and there was, when he acknowledged he wasn't the custodian, it didn't seem like there was much that happened after that.
I don't think that Mr. Crawford ever specifically acknowledged that he was not the custodian of records. He said, according to appellant's counsel's description of what a custodian of records was, that didn't fit his position. I don't believe the record necessarily says that he was not a custodian of records, but according to appellant's discussion.
But you agree that he's not a custodian of the records, Isn't your argument that you don't need to be the custodian to provide foundation for this particular document?
My argument is that he does not need to be a custodian of records to authenticate this document, yet because the bank does not have an official custodian of records, he has signed an affidavit that is in the record that he is an appropriate person to sign an affidavit as a custodian of records. So according to appellant's definition, he was not a custodian of record, but I want to make it clear that he could be considered a custodian of records under other definitions more appropriate to this.
Well, doesn't Rule 803 contemplate the custodian records or other qualified witness? I mean, what?
An appropriate person can be someone who doesn't have to be a custodian of records.
That's correct, and that's what we're asserting in this case, and that's why Mr. Crawford later signed an affidavit saying he was a custodian of records, even though at the hearing he acknowledged, according to appellant's counsel's definition, he was not a custodian of record. And the discussion that appellant's counsel had earlier about the discussions regarding entering into the stipulation, I was not party to any of those discussions, and I don't think it's appropriate for appellant's counsel to assert that somebody who's not here and that nobody here was part of those discussions, what actually went on and who indicated which part of the stipulation who is appropriate. And although the appellant's counsel in the reply brief indicates that the other bases that the launch could have been admitted under are new issues, rather this court has discretion to affirm the judgment below if there's any legal basis to support that. And so therefore they're not new issues, but rather alternative bases on which this could have been, the launch could have been submitted as evidence, such as a signed instrument with independent legal significance, a business record, a self-authenticating document, and alternatively, the trial court has a inherent power to correct its orders if it sees fit. And if there are no further questions, I will sit down. Thank you.
Thank you both for your argument. We will take this matter under advisement and issue a decision in due course, and we will take a brief recess to prepare the courtroom for the next argument.
Nice to meet you. Nice to meet you. Good job. Good luck. Yeah, good job, Francie.